So, are all the people sentenced for rioting about to have their sentences overturned? Will they be getting compensation? Will judges be getting fired for sentencing them? Well, I can tell you now, no, but you might have got that impression from social media recently. So what's this all about? Well, we've actually had the first of the rioting appeals. Well, I say appeals, they were more sort of leave to appeals, but I'll come on to that momentarily. And indeed, one lad has had his sentence reduced, or at least turned into a suspended sentence. But what's all this about? Well, there were 4 people initially, and they have all applied for leave to appeal against their sentences. Now, just to explain, if you want to appeal a sentence, you have to show that it is manifestly excessive. Not just that it's a bit higher than normal, or you were treated differently to somebody else, or other people got a lower sentence. You have to show your specific sentence was, like I say, manifestly excessive. And also, you don't have an automatic right of appeal. You have to first of all apply for leave to appeal. You have to say, look, there are arguable grounds for, allowing me to have this appeal. So 4 people have brought this initially, and we have the first 4 results. So I'll just go through. Now, they were all dealt with together because they obviously had some common features. But what the court said is, they reminded us, when sentencing an adult aged 18 or over at the time of conviction, the court, quote, must have regard to the following purposes of sentencing. A, the punishment of offenders. B, the reduction of crime, including its reduction by deterrence. Because that's, you can also, it reduces crime because while you're locked up, you're not committing crime, are you? But also the idea is that we have individual deterrence, i.e. we sentence you to prison, you might not want to do it again. But also general deterrence, people reading about all this sort of thing, that might put them off committing crime. Although, as we've discussed on previous occasions, as to whether that is effective is a very open question. I mean, most of the research suggests that for most offending, it's actually the fear of detection that is the deterrent, not the actual sentence. But also C, the reform and rehabilitation of offenders. D, the protection of the public. And E, the making of reparation by offenders to persons affected by their offences. In other words, that's the retribution element, the punishment element. But what the court said here is they said, well, look, when you look at public order offending, that throws them into a different bracket, because you don't really look at just what the individual person did. You need to look at the context. And the actual quote, it's a case called Fox and Hicks. And that said, in the case of public disorder, it is important for the court to look at the whole picture. And although what an individual may have done by himself is of relevance, that is simply part of the whole to which he is contributing in his way, and the larger picture must be taken account of. Because, these people were done for public order offences. They weren't done for individual offences. If you just get into a scrap with somebody in the pub car park, you might both get done for one of you might get done for ABH or GBH or assault or something like that. But if it's, a public element, like, oh, hang on, people are a bit scared, people walking past see that, then it becomes a public order offence, it becomes an affray. So like, if you're gonna get into a fight, do it somewhere private, basically. And they said, there is an overwhelming obligation on sentencing courts to do what they can to ensure the protection of the public, whether in their homes, on their businesses, or in the street, and protect the homes and businesses and the streets in which people live and work. This is an imperative. The imposition of severe sentences intended to provide both punishment and deterrence must follow. It is very simple. Those who deliberately participate in disturbances of this magnitude, causing injury and damage and fear to even the most stout-hearted of citizens, and who individually commit further crimes during the course of the riots, are committing aggravated crimes. They must be punished accordingly, and the sentences should be designed to deter others from similar criminal activity. And it's what we talk about. We talk about exemplary sentences, you know, making an example of people. You know, as Voltaire said, you know, every now and again the English like to execute an admiral to encourage the others. And that's, you know, that's the general principle. And they looked back and they said, well, look, we've dealt with all this back in 2011. Because, you know, there was the rioting then. You remember, you know, people were getting nicked and people were getting 6 months for shoplifting a bottle of water. Now, normally if you shoplifted a bottle of water, I mean, you might not even be proceeded against, but, you know, chances are, worst case scenario, you're going to get a caution. What is a caution, by the way? I suppose I should cover that. A caution is a way of disposing of an offence without it actually going to court. The thing with the caution is that you have to admit the offence. So it's an admission of guilt, but it doesn't count as a conviction, although it goes, quotes, on your criminal record. And it's really weird, really, because we don't really have criminal records per se in this country. I mean, there's a form called an MG16 that will list all your previous convictions, but it also includes things like cautions. And then, of course, we got to DBS checks. Maybe that might be a subject for a video, actually. But, you know, you have your standard, your basic, and your enhanced DBSs. There are 3 different levels. And, you know, the first one will just show offences that you are convicted of, but not including spent offences. Then you might get one that shows all the offences you've been convicted of, including spent offences, because there are some jobs where you have to declare even spent convictions. And then the most severe, which I'd actually had to do, that shows everything. That includes showing all the police intelligence on you. It's quite interesting, you know, sort of like, are you suspected of any involvement in offending or anything like that? I mean, it's interesting, you know, what you can actually find in there. But when we come on to these things, so like, you know, like I say, so, you know, a caution then, but you got 6 months. And what the court's saying is, look, we've been through all this before. There's no new law here. You know, nobody's like going to argue any great legal principles or anything like that. We've been through all that, so let's look at some of the individual sentences. Well, there's a guy with the great name of Ozzy Cush. He got done for violent disorder. As they say, your action in kicking the officer was clearly deliberate. It displayed a complete contempt for the police on your part. You clearly intended to make contact with the officer and cause him physical harm. Your action also ran the risk of inflaming the wider situation and encouraging others to attack the police. Although, fortunately, at that time, that did not happen. And what they said there is, you got 16 weeks. Yeah, that's fine. We think that's pretty, you know, that's pretty reasonable. You assaulted a police officer, which is bad enough, but you assaulted him in the middle of a riot when there were loads of other people around who might have joined in. So his appeal, he didn't even get leave to appeal. They said we refuse leave to appeal. So that was the end of it. There's another guy, a Mr. Paul Williams. And again, what did he get done for? Yep, he again, violent disorder. So the court said it's an unavoidable feature of mass disorder that each individual act, whatever might be its character taken on its own, inflames and encourages others to behave in a similar fashion. That is why the court will have regard to the overall picture. Those participating in mass disorder must expect severe sentences intended not only to punish, but also to deter others from copying their example. And the judge looked at all this. He went through all the sentencing guidelines. And it said the sentence he came to before credit for the guilty plea was 3 years, 3 months imprisonment. He knocked off the discount for the guilty plea. And the issue there was they were just saying, well, look, could you suspend this sentence? It could have been dealt with by way of a suspended sentence. The trouble with that is you can only suspend a sentence if it's a maximum of 2 year sentence. And what the court said here is, well, going through the sentencing guidelines, unfortunately, it's just not a sentence that, as a matter of law, could be suspended. Nice try, so we're going to refuse leave on that. I mean, generally speaking, you're going to get a suspended sentence if, first of all, it's, you know, no more than 2 years, but also if there's a realistic prospect of rehabilitation, there's very strong personal mitigation. You know, that's the sort of reasons, or that it, you know, an imprisonment, immediate imprisonment might have an effect on innocent third parties. I mean, that's why, you know, a lot of people who do shoplifting when they're single mums, and, you know, they might normally go to prison, but the court's going to go, if we send you to prison, your kids are going into care, and whatever we think of you, it's not really fair on the kids. I'll come back to the main guy in a moment. There's another guy, actually. Aminadab Temesgen. And what's interesting there is he actually sort of succeeded on his appeal. Again, he got done for, the violence and everything. But he got a sentence of 14 months imprisonment. However, they actually pointed out and said, actually, because of his age, you can't send him to prison. He can only be dealt with in a young offenders institution. So what the court said there, for those reasons, there are no good grounds on which to challenge the imposition of an immediate sentence of 14 months custody. The sentence was expressed as one of imprisonment, a sentence which was not available because of the appellant's age. The sentence was therefore unlawful and must be corrected. Though the correction will make no difference to the length of sentence, we accordingly allow the appeal to the extent that we quash the sentence of 14 months imprisonment and substitute a sentence of 14 months detention in a young offender institution. So, probably doesn't make a lot of difference. I don't know if Feltham's still open. I used to go there a lot. They had peacocks. Now, interestingly, young offenders actually, they can actually end up in prison. There's a thing called Starred Up, which is not just the name of a rather excellent film, it's also the procedure where they say, you're not suitable for a young offenders institution. So even though you are a young person, we're going to send you to big boys prison. I mean, in all fairness, sometimes that's, for their own benefit. It's like, actually, you're too mature, to be in here. There's that excellent film Scum. I love both versions, the TV play and the actual film. But there's a bit in there where the guy says to Archer, you're too bright to be in here with this lot. You should have got a sentence of imprisonment. But anyway, the one that everyone's making all the fuss about, this is a guy called Dylan Willis. He was 18, previous good character. Did have a lot of personal mitigation. He had sort of various issues. He had diagnosed with ADHD and there were other mental health concerns, including self-harm. And the pre-sentence report said, well, actually, how about some, a non-custodial? How about a bit of community service? But it said the judge was faced with a difficult sentencing exercise, dealing with a complex offender as similar disturbances racked the country. His choice under the category of the guidelines was unarguably correct, and his addition of some months for the aggravation of the broader context of the applicant's offending was, if anything, moderate. To state, as we have done, that an offender's sentence has to reflect both the actions and the overall disturbance is not to say that the nature and extent of the individual actions are immaterial. So what they're saying there is, yes, we've got all this broader context stuff, and you take that into account, but it doesn't completely negate your own individual actions. Because as I said before, in this country, we tend to sentence based on culpability, not consequence. What were your voluntary actions? What did you do? Because that's the bit you're in control of, isn't it? Not necessarily what the consequences are. But at the same time, they say you must, either be aware or be deemed to be aware that when you're doing this in a rioting context, then it is obviously more serious. But they said, in the probation officer's assessment, the appellant's ADHD and autistic spectrum condition significantly impacted his thinking and conduct. The judge was rightly directed to the Sentencing Council guidelines for offenders with mental disorders, development disorders, or neurological impairments. The applicant would easily be drawn by others, and his lack of maturity played a role in his offending behaviour. The applicant's various intellectual and development problems also meant he was vulnerable to unhelpful influences. So, and also including when he was in custody, they didn't want him re-radicalised. So here the court is showing a little bit of mercy because of this particular lad's, particular conditions. I mentioned before, I'm very wary about people playing the mental health card to get out of things, because first of all, it stigmatises people with mental health conditions, most of whom do not commit crime. I mean, statistically, people with mental health conditions are more likely to be the victim of a crime than to commit a crime. But at the same time, you do take these sorts of things into account. It's not just, I've said it's sentencing by spreadsheet, but this is one of the things you put into the spreadsheet. And the court said, we have found this a difficult decision. We are persuaded that the exceptional and exceptionally powerful combination of personal mitigating features should have led the judge to conclude that appropriate punishment could have been achieved by a suspended sentence. But they do go on to say, accordingly, whilst we have hesitated to differ from the conclusion reached by the judge, We have concluded that this court should interfere with the decision below. We therefore grant leave to appeal. We quash the sentence of 14 months immediate detention and substitute a sentence of 14 months detention in a YOI, Young Offenders Institution, suspended for 2 years with a rehabilitation activity requirement up to 40 days. So that's what they've done. They said, your particular personal mitigation is such that, okay, we can make this a suspended sentence. And in the grand scheme of things, it might be better. Bearing in mind, you probably got involved in this, not because you believed in the cause or anything like that, but just other people took advantage of you and led you on. So therefore, while you do have to stand up to such people, we'll give you a little bit of help in actually doing that. And that's what the rehabilitation activity requirement will be. You know, he'll get sort of guidance and counselling. He'll, probably have to do some sort of reparatory work. It might be writing letters to people or just acknowledging what he did is wrong. But what they're saying there is, actually, we need you to just be able to think better and to actually say no to people. So that's what they've done. So all this idea, though, you'll notice there, I mean, first of all, they said, this is, only just crosses the threshold. And they said they were very reluctant to interfere with the judge. They said the judge pretty much, we understand why the judge did it. And yes, we have said, okay, he could have done something differently. So we are actually going to allow this. But when people are sort of going, this is it, this is the floodgates, everybody's going to now be released and judges are going to be sacked and people are going to get compensation. Well, on the basis of this, they're clearly not. I mean, like I say, the first 4 applications for leave have gone through. 2 were knocked back straight away. One guy, there was a technical issue, so they just resentenced him to the exact same amount of time, but actually in the correct institution. And they've allowed one lad to actually have his sentence suspended just because of his very strong personal mitigation. But you'll notice there's absolutely zero criticism of the judge. So like I say, I don't think this is going to open the floodgates, and it gives you an interesting, I mean, like I say, there's nothing particularly surprising in this, because we did go through all this in 2011, so the law is very clear. An activity that if you were to just do it in normal circumstances might get you a bit of a ticking off. If you do it when there's serious public disorder, then you're going to get the full weight of the law and the book thrown at you. So there you go. As always, hope you found that vaguely interesting, vaguely informative, vaguely accurate. I'd just like to keep saying thank you. I'm feeling a lot better with everything. Actually went on a little drive today. And I have to say, it doesn't appear to have affected my driving, which is a pretty appalling standard anyway. But I got back with relatively few like prams, pushchairs or bicycles stuck in the grill. So I'm calling that a success.